We're here for a final pretrial conference. Is there any resolution?
Yes, Your Honor. It's my understanding that defendant will plead guilty to an added count of disturbing.
And just like that, we're skipping past a domestic violence charge and heading into disturbing the peace. But why the downgrade? Is this a smart legal move or a missed opportunity for justice?
Peace, and the people will dismiss count 1, domestic violence.
Mr. Hertel?
It is accurate, Your Honor.
Mr. Stokes, have you heard what the attorney said the resolution in this case is?
Yes, sir.
And is that how you wish to resolve it?
Yes, sir.
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? All right. Sir, it's my understanding that you will be pleading guilty to an added count 2 of disturbing the peace. That is a 90-day misdemeanor and a fine It's a 90-day misdemeanor and a fine of up to $500. In exchange for that, the people will dismiss count number 1 of domestic violence. That is a 93-day misdemeanor and or a fine of $500. Is that your understanding of the plea agreement?
Yes, sir.
Other than, let me ask you, were you on probation or parole back on May 27th?
Yes, sir.
Were you on bond?
No.
Do you remember reading and signing this advice and rights form, talk about your rights to a trial and your rights to an attorney? Mr. Hartel?
Yeah. You have any questions? Yes, sir.
You remember reading and signing that? Did you understand those rights?
Yes.
Do you have any questions for me about those rights?
No, sir.
Most importantly, do you understand that by entering a guilty plea today, you'll be giving up the right to have a trial and you won't have a trial of any kind?
That right there, a guilty plea meaning no trial, no jury, no chance to fully fight the case. Sometimes it's strategic, but it also means the truth might stay buried under the surface.
Yes, sir.
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No.
Has anybody threatened you? And is it your own free choice to plead?
Yes.
Are counsel aware of any other promises, threats, or inducements that are not made part of the record?
No, Your Honor.
No, Your Honor.
Then Mr. Stokes, to the added count that on or about May 27th, 2025, in Antioch Township of Wexford County, that you did disturb the peace, how do you plead?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on May 27th, were you in Antioch Township?
Yes.
And would you agree with me that that's in Wexford County?
Yes, sir.
And did you disturb the peace somehow?
Yes, sir.
How did you do that?
Yelling and screaming, things thrown in the yard. Neighbors could hear.
And do you agree that that would have created a disturbance?
Yes, sir.
Do counsel believe that the defendants provided a factual basis in which to accept the plea and that the court rules have been complied with?
Yes, Your Honor.
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Mr. Stokes, I find you guilty of disturbing the peace. Pursuant to the plea agreement, the domestic violence charge will be dismissed. Are we able to sentence today?
Yes, Your Honor, and I do believe the victim is here to let this be.
Okay, all right. Good morning. Could you please state your name for the record?
Lisa Six.
All right, and Ms. Six, what is it that you would like me to know?
I agreed to the disturbing the peace because I did not want him to lose his gun rights. Once he accepted the plea, he regularly posts things on Facebook to
Here comes the emotional bombshell. The victim's about to speak, and her story. It paints a far more disturbing picture than any legal document ever could.
To harm me. I have a business for dog boarding. He claims that I killed his dog. He's posting that I killed his dog on Facebook. People are harassing me. And also that all my doors at my house do not lock because he's broken all the doors down. And that day on May 27th that he abused me, he nearly broke my arm and destroyed my house. And I just wanted to say that the reason I did not want him to get domestic violence is because I didn't want him to lose his gun rights.
When did the Facebook postings occur?
Today, yesterday, and multiple times. I mean, he blackmails me when I do not do what he wants me to do. And he posts things like that all the time on Facebook.
So describe for me a little bit more about how is he posting things on Facebook?
He posted a picture of our dog, who I purchased, I care for, and he captured it at the top. The 6 killed my dog. Or he said, Camp 6 killed my dog. And then I was getting harassed by people that would find me on Instagram and find all my socials and harassing me, saying that they're going to harm me or sue me, or that I'm a horrible person. When I take care of the dogs every day. He does nothing with them. When my dog was found dead, I went to go I picked him up and I took him and I buried him by myself. He did not care. He just posts these things to hurt me until I do what he wants me to do. Actually, the last time that he does not want me to post any pictures of myself on any social media. And so I changed my picture, and that was why he posted it last time. And he refuses to remove the posts until I change or do whatever he wants me to do, or if I don't let him come back to the house after he's abused me or gone to cheat on me for a week at a time, he comes back and breaks down the doors and he posts things about me.
The postings that you've referenced since this event happened, are you tagged in those?
He will, yes, but I have him blocked now, so he can't tag me, but he has certainly tagged me many, many times.
Has that
tagged my family, tagged my sons.
Has that occurred since May 28th?
Yes.
Okay. Anything else you'd like me to know?
This isn't just a breakup gone bad. This is about fear, control, and harassment that goes way beyond disturbing the peace. Her testimony shakes the courtroom and possibly the entire plea deal.
No, sir. It's very embarrassing. I don't want to. There's so many things after 5 years being with them.
Okay. Thank you for being here today. You've shed a lot of light on this case for me, so I appreciate that. You can stay where you're at, or you can go back with Ms. Brick if you'd like. Mr. Hartel, allocution?
Yes, thank you, Your Honor. What I will say is we are grateful for this plea. Just so the court is aware, the factual basis my client gave is pretty consistent with what he's been telling me the entire time. We realize there's allegations that go beyond his factual basis. He's been firm with the fact of things that he agreed with and things he didn't agree with. We thank Ms. Six for her testimony, but just so the court is aware, we don't necessarily agree with that testimony. As far as more recent events, I, like the court, was unaware of those allegations. I did sidebar briefly with my client. He informed me that he denies tagging anyone in anything, violating any no contact orders, just so the court is aware. I realize the court will likely factor that into the sentence. I would ask the court to consider keeping this on the minimum end of it. I realize there has been some victim input expressed in the court. I would ask the court still to consider fines and costs in this matter. Other than the allegations that we heard just now, to my knowledge, I don't believe there's been any prior allegations of bond violations. If the court felt it rose to the level of probation, I don't doubt my client would do well on probation. I definitely don't feel this has risen to the level of incarceration, but I would ask the court to factor in that I truly believe that my client has no intent to have these events occur again. And again, if the court felt like supervising him, I don't doubt he would do well in supervision. Thank you.
Thank you. Ms. Lawrence?
Thank you, Your Honor. I think the victim's statement speaks a lot of volumes into this case.
Two realities. The defense calls it exaggerated. The prosecution says it's alarming. The judge, now stuck in the middle with some serious decisions to make.
Our office was made aware of some of the statements that she made just this morning before this. which is extremely concerning to the people because it feels like the defendant is not taking this seriously at all. Some of the things he has allegedly been posting online. I do understand he is pleading to disturbing the peace, but I do think this is one of those cases where maybe supervision would be appropriate. I will leave the sentence up to the discretion of the court. Thank you.
What are the allegations, at least as reported to law enforcement?
This incident, the defendant was drinking. They got into an argument, throwing items at her. And one of those items was a vintage radio that bruised her arm, and I believe the radio broke or shattered.
Anything else?
No, yeah.
Mr. Stokes, you do have the right to address the court prior to sentencing. Is there anything you'd like me to know?
I posted a picture of my dog, and he was killed at Camp 6, let out on purpose with that intent. I posted a picture. I didn't tag anybody's name. I posted 3 of the pictures, and all 3 were GPSs I found in my vehicles. One was sewn in my toiletry bag, and the other one was found, I can't recall what the third one was found. Those were all recent. My sister let me know it was upsetting. It's not right to do, but those posts are up.
What was your reason for posting the pictures?
I just miss my dog. So, every time I see it, it upsets me. But it was how it went down, how I was text. I hit her block. I was text several times by her that my dog she let my dog out. I'm sorry for your loss. That was 9 months ago. That happened.
Well, she says the postings occurred after I placed you on bond.
Yes, sir. Yes.
Did they occur after I placed you on bond? And so it wasn't enough that you posted that your dog was deceased. You indicated that it happened at, I think you're saying, Camp 6?
Yes, sir.
And I assume Ms. 6 is tied to Camp 6?
Yes, sir. And they were posted I posted the picture twice for one day. And I had it posted for hours, and my sister told me it was wrong. Don't put that on there.
Anything else? Well, Mr. Hartel is correct. Even though there hasn't been a violation, I'm certainly going to take into account the fact that you, for all intent and purposes, violated the court's no contact order. And I also feel as though, well, Ms. 6 indicated that she signed on to the plea agreement. I think she did that out of her own necessity and not necessarily for lack of wanting to follow through with the case. I always get reluctant when we have plea agreements that try to skirt what the legislature has intended, and that's the keeping of gun rights, because the legislature has determined that in domestic violence situations, a person should not be entitled to keep their gun rights, right, wrong, or indifferent. And so when we skirt these for the purposes of keeping gun rights, I do question whether or not the people of the community are well protected. And now I have, out of what appears to be fits of rage, not only is it enough that, at least allegedly, I realize what you pled to is a disturbing the peace, but allegedly you're throwing items at the victim, and now...
Boom, the judge drops the truth. You pled to a lesser charge, but your behavior screams otherwise. this sentence. It's not just about what you admit, it's about everything you tried to avoid admitting.
You continue to victimize her by posting essentially that she killed your dog or that your dog died while in her care. One of the things that the court has to consider is keeping, in cases such as this, victims safe, community safe, determine whether or not it's appropriate to place somebody on probation, and a deterrence as well. It's not lost on me that this was a pled to a disturbing the peace, but what also is not lost on me is that I had 90 days jail at my disposal. Just because it's a disturbing the peace does not automatically mean it's a fines and costs situation. And while the caption of the statute, disturbing the peace, may make it seem minor, I am allowed to consider the allegations of the case. And I'm considering the allegations of the case and the fact that you violated the court's no contact order when I impose a sentence. The court is going to impose a 60-day jail sentence with 1 day credit. I'm also going to impose a probationary period for 12 months. During that time, you're not to violate any law, report as ordered, not leave the state of Michigan without the consent of your probation officer, keep your contact and employment information current. I do not believe that you are eligible for early release because this started as a domestic situation despite what it was pled to. I think the facts of the case keep it at a domestic situation. So as such, you are not eligible for early release. During that period of time that you are on probation, you are not to consume any alcohol, no illegal drugs, including recreational marijuana. You'll be subject to testing pursuant to the conditions of your probation officer. No bars where the primary source of business is the sale of alcohol. No alcohol or illegal drugs where you reside. You must attend counseling pursuant to the terms of your probation officer, including drugs and alcohol counseling and anger management. During the time that you are on probation, you are not to act in any violent, threatening, intimidating, harassing behavior. No purchase or possession of firearms or weapons. If you are employed, I'm going to order that you sign a wage assignment with your employer. There will be a $75 crime victims' rights fee, $50 state minimum fee, $500 fine, $150 court costs, $150 attorney fee. Probation fee for the 12 months is $360. Also, during the time that you are on probation, Ms. Lawrence, do we have any input regarding the no contact order?
Not that I'm aware of.
Court will continue the no contact order during the period of time that you're on probation unless it receives a motion to reconsider it.
And it's done. 60 days in jail, 12 months probation, and zero tolerance moving forward. But more importantly, a clear reminder: plea deals may reduce the charge, but they don't erase the impact.
Is there anything else in the judgment of sentence, Ms. Lawrence, that I've missed?
No, Your Honor.
Mr. Hartel?
No, Your Honor.
Mr. Stokes, because I have sentenced you to a term of jail, you do have the right to appeal that decision. If you decide that you want to appeal it and cannot afford an attorney to assist you, you have 14 days from today's date in which to request the appointment of an attorney. Additionally, any balance of the fines and costs that remain unpaid for more than 56 days will have a 20% penalty assessed. Anything else? Hearing none, we are adjourned.